Good afternoon, and welcome to Venable and our program today entitled Implementing a Bring Your Own Device Policy, What Your Nonprofit Needs to Know. My name is Jeff Tenenbaum, Chair of the Nonprofit Organizations Practice here at the Venable Law Firm. And this program is part of the monthly series of webinars and seminars that we do on a wide variety of nonprofit legal topics that in April will be 3 years now. I know many of you are repeat attendees at many of these programs, both in person here in D.C. We have a nice crowd who joined us for lunch in our Washington, D.C. office, and a pretty big crowd on the telephone across the country today. In that vein, let me give you a quick promotion for our two scheduled upcoming programs that we have on the books so far. Next month, our program on March 20th will be entitled The OMB Super Circular, What the New Rules Mean for Nonprofit Recipients of Federal Awards. The new Super Circular is the final version that the U.S. Office of Management and Budget put out that basically consolidates all of the primary federal rules governing award recipients from federal grants, contracts, and cooperative agreements. It's a pretty important, pretty comprehensive set of new rules that's having pretty massive implications for any and all federal award recipients, including nonprofit organizations. It's an area in which my colleagues and I here at Venable do a lot of work. We have a terrific program lined up for you next month, including a terrific outside speaker who's going to join us as well. And then on April 29th, our program is entitled Election Year Advocacy, Maintaining Your Nonprofit's Clear Message in Cloudy Legal Seas. This is a program that's going to be very much relevant to all different types of tax-exempt organizations, 501c4s, C6s, and 501c3s. I think it's going to be a really terrific program led by two of my colleagues who co-chair our political law group and do extensive work with nonprofit tax-exempt organizations in this space. We'd encourage you to sign up and participate in those programs, either in person or on the telephone. Today's topic is a really terrific one. It's an area in which we've been doing quite a bit of work now for a number of years, but it's an area, whenever a term, like in this case, bring your own device, kind of boils up and develops a life of its own, there's always no shortage of very important, interesting, and challenging legal issues that go along with that. We're going to be tackling those issues today and hopefully be able to answer a lot of the questions and concerns that you may have in this area. Before I introduce our speakers, a few housekeeping matters. First, for those of you who are in the room here in D.C., you have a handout booklet that has a printed copy of the PowerPoint slides, as well as speaker biographies and a number of related articles on directly and indirectly related topics that we'd encourage you to take a look at. Those of you in the webinar, as part of the confirmation email that you received, I believe yesterday, you should have a copy of the PowerPoint slides, and everyone tomorrow will receive an email that contains a link to a recording of today's webinar that you should feel free to share with colleagues and others who might benefit from it, as well as all of the PowerPoint slides and handout materials. We do have quite a bit of material to cover here today, so as a consequence, we're going to have to hold questions until the end. Those of you in the room will be able to ask questions just by raising your hand. Kelly in the back of the room has a handheld microphone. She'll walk around and just wait for that mic before you ask your question so those on the telephone can hear. And for those on the webinar, please send me your questions using the chat feature on the webcast software. I'll be manning the laptop in the front of the room, and we'll pose those questions to our speakers at the end of the program. We also have some pretty interesting hypotheticals that hopefully we're going to have time to get through, and those I think will address a lot of your issues and questions as well. We are very fortunate to have two of my partners here at Venable and two of my colleagues with whom I've worked for many, many years, and both of whom I've worked with many of our nonprofit clients, hundreds and hundreds of our nonprofit clients over the years. They're both extremely talented lawyers and know this material very well as well. I think you're going to really enjoy hearing from both of them. To my immediate right is AJ Zatola. AJ is a member of the firm's Technology Transactions and Outsourcing Group. But the way that we typically describe and view AJ is pretty much anything technology related, and every legal issue that comes up with respect to technology kind of falls into AJ's category. And we're talking about everything from the contracts to the intellectual property to the privacy, the defamation, and everything else that goes along with that. AJ also has a technology background himself, which is extremely helpful. I can't even count how many contracts he's reviewed and negotiated for our association and nonprofit clients and how much counseling he does in this area. He's really a terrific resource for us, our clients, and will be here for you today. And to Dave's right is Dave Warner. For those of you who might have seen the original promotion for this program, Dave looks a little different than Ron Taylor, who was supposed to be sitting here today.
Actually, a great deal different than Ron Taylor, I should think.
Much better looking, of course. Ron, unfortunately, had an emergency client hearing in Maryland that he had to be at today. Dave graciously agreed to step in for Ron, and Dave thankfully also does a lot of work in this area. Dave is going to be focusing on the employment law-related aspects of these issues today. Dave is a partner in our labor and employment practice. Dave has been the go-to lawyer who I've turned to for years and years, as have many of our nonprofit clients, in counseling them through the very difficult and complex labor and employment issues that nonprofits face, as well as defending them when they need defending in various employment-related actions. Dave is a fantastic lawyer and a great speaker as well, and I know you'll enjoy hearing from him today. With that, I'm going to turn it over to AJ. Well, actually, before I turn it over to AJ, I'm going to just give you a brief overview of what we're going to cover here today. First off, and we're going to kind of bounce back and forth a little bit between AJ and Dave this afternoon. AJ is going to start off by talking about some current hot-button issues in the area, going to give you an overview of bring your own device policies. Dave's then going to talk about integrating bring your own device policies into your workforce. They're going to talk about lessons from the front lines. Hopefully we'll be able to get to some hypotheticals that we've come up with, and then finally talk about takeaways, tips, and answer your questions. So with that, I'm going to turn it over to AJ.
Good afternoon, everybody. Thanks for coming. Today we're going to walk you through bring your own device policies. And this is an area that has a lot of overlap within the law, and also I think you're going to find that within your own organizations it cuts across a lot of your different subject matter areas. And so there's a lot to cover, and when you finish this presentation, I hope you walk away thinking that this isn't just a technology issue, it's really a combination of things. It's almost as if you're extending your workplace environment to the mobile world. So let's just start at the beginning. What is bring your own device? I mean, quite simply, it's a mobile device policy. It has a definition like anything else, at least in terms of how the government's defined it, and the government is a big proponent of BYOD, but in terms of how you should be thinking about it, it's essentially central management of all your devices, and these days most people tend to utilize personal devices for employment purposes. I myself have my own iPhone that I use for work email. And so BYOD was devised as a policy approach to address situations where you are dealing mostly with personally owned devices as opposed to organization-owned, although certainly much of what you're going to hear today will apply to organization-issued devices as well. And it has a couple of critical elements. Tends to deal with confidentiality, the handling of sensitive or non-public information. It tends to deal with access, maintaining integrity of data, because these days we don't necessarily work within a centralized work environment anymore. People can access from anywhere. And then finally, it's talking about availability. I mean, this notion of 24/7 is both good and bad. In this respect, though, you need to be considering that people are no longer coming in and working 9 to 5. They are working from different locations and at all hours of the day. And so BYOD is the policy approach to manage all of these issues. So when you think about BYOD, what we thought was going to be helpful, and we're going to go over these at the end of the presentation, were a couple hypotheticals to give you a sense of where a BYOD policy could be most useful and where it could be implemented. But as you'll see from the hypotheticals, we're going to be talking about use by executives, dual-use devices, devices that are infected with malware or some type of virus, and of course in situations where your organization is in the middle of a legal proceeding. Those tend to be the kind of situations where having a BYOD policy can be really critical to handling and addressing what happens next. So what are the current issues? Well, chief among them is unsecure information. These devices are being used outside the four corners of your office. And so you need to be accounting for them just the way you would account for computing devices within your office. In many respects, most of these devices also tend to have less security unless you are adding security measures. And so when you were thinking of BYOD, you were also thinking about how to maintain the security of the information that is not just residing on the device, but also may be accessible through the device. You also need to be considering the fact that, to an extent, your business operations will just be presumed to extend to and through these devices. So one area where this is most easily seen is with respect to the handling of trade secret information, non-public, confidential information. You still have these same obligations to maintain that information that is available through your mobile device just as much as you would through other documents or computing systems that would reside within your main office. You need to account for the fact that these are portable devices. They get lost, misplaced. Many of the incidents that occur these days are not always being driven by people who have tried to force unauthorized access. They are simply occurring because somebody lost something, leaving the laptop in the cab, leaving the phone on the plane. I mean, that's oftentimes what gives rise to security incidents. These devices, because they're possibly personally owned, are going to have an environment where within the device itself you have an overlap of both the work world and the personal world. The devices use personal apps, they use work-related apps, they involve your personal communication, social media interaction, as well as communications established for work. And trying to clarify that gray area can be rather complicated. And so you need to be thinking about this a little bit, particularly as it relates to how these devices might store information, in particular personal information. You need to be thinking about whether or not you can retrieve information off these devices. So if the device has something valuable on it and it gets lost, or an employee leaves, how can you get that information back? And you also need to be thinking about how you are going to enforce your employment rules or guidelines over a device that is not your property. I am aware of a fact, this came in this week, somebody asked if they could hold on to a phone while an employee traveled abroad because they had no security policy in place to address remote access and no controls for that remote access, and they were trying to figure out a way to control this person's travel abroad and making sure that nothing happened to the phone. So they thought the simplest solution was just to take it. And I asked if this is a device that they had purchased, and it is not. And so you need to be thinking about the fact that you are dealing sometimes with personal property over which you may not necessarily have the right or the ability to control what happens. There's also many, many privacy issues that can be attached to the mobile device. To a certain extent, the law will treat access through the mobile device no differently as access through a website or a standalone computing device. And so you need to be aware that to the extent your devices store personal information, and that can be your organization's lists, business representatives, meeting member notes, etc., you need to account for that personally identifiable information the same way you would in other environments, such as through your website. You also need to be aware that to the extent security incidents do occur, breaches do occur, you need to treat these devices the same as if they had occurred within your own workplace environment or on your own workplace network. So we're going to go over a little bit about what these policies should cover. And to a certain extent, what's critical here is that you understand this is not necessarily a legal policy. BYOD is really a policy that incorporates a lot of different elements from within the organizations. You should be giving thought to, obviously, legal issues, but there are simple security, IT access, and employment issues that should be incorporated into your policy. Simple things like establishing a password. I mean, that's not necessarily a legal issue, although it can have ramifications on legal concerns. But these are policies for which your organization as a whole needs to have input from all the associated departments that handle these issues. Don't just rely upon the lawyer to draft these things, because the lawyer may not necessarily understand all the elements that should go into it in terms of dealing with your workforce. But some basic things that should be established through the policy are, defining who it's subject for. Is it just those devices that are owned by the employees? At all devices? It may be administratively easier for it just simply to be all devices that can access your workplace network. What conduct? Work-related, all conduct that occurs over the device. Security. You should have security protocols, security measures as a part of access, as a part of using these devices for work-related reasons. And what rules will you be establishing? Monitoring. As a part of security, it's natural to also want to monitor access, to monitor what's being transmitted, to monitor what's happening over the device. How will you establish your right to monitor? User support. Things get lost, people have issues. How will you deal with that? In particular, dealing with an incident where there might be loss of data, unauthorized access because of a lost device. Having something as simple as having a phone number to call so that you can deal with this in a timely manner can be critical to your policy. And finally, policy violations. If there are going to be labor and employment concerns, which we'll certainly deal with today, you need to establish up front that violations of your BYOD policy can lead to other penalties, etc. Your BYOD policy is still subject to law. Now, many of the laws that have been drafted have not yet been revised to account for mobile devices, but for your purposes, it's probably safe to assume that they will treat your mobile device no differently than any other computing device that's within your workplace network. So if you deal with medical information or financial records subject to HIPAA or Gramm-Leach-Bliley, the access through the mobile device will be treated no differently than an access through a website or through your own computing network within your office. And so remember, these laws essentially still apply, notwithstanding the fact that they're not necessarily drafted for BYOD or for mobile devices. Other rules still apply to BYOD similarly. If you are keeping information on your devices or allowing your employees to keep information on your devices, then your BYOD needs to at least account for the fact that that information will be treated as if it's been stored internally. And so to the extent you have rules for keeping records because of your dealings with other business partners, this is most easily seen in a government contracting context. But certainly if you have dealings with the government, even local or federal or state, they have rules for how you have to hold on to records. Those rules still apply to these devices. Certain states have information security laws. Those laws, even though not drafted, will still apply to these devices. And in particular, those laws tend to require a measure of security for personal information. To the extent your devices are going to hold on to personal information, if you have a membership directory, if you have a network directory, if you have a list of contacts and you have their personal information, on those phones, those information security rules still apply, meaning that you need to be implementing security for the mobile devices. This is even more complicated sometimes if the mobile device is not something that you own and control. For those devices that are dual use, meaning it's a personally purchased device that is also used for workplace, then you need to be coming up with some security measures for that. Typically that means controlled access, secured access, password access. Additional policy considerations for your BYOD policy. You don't need to reinvent the wheel. BYOD should fit into the existing policies that all of your organizations are going to have. So you're not considering this in a vacuum. You, in fact, are taking what you already use and fitting BYOD into it. And so to the extent you have existing confidentiality policies, non-disclosure policies, email usage, computer access, internet usage, social media access usage, take all that thinking and apply it to mobile device. The mobile device can access social media just the same as you can through a standalone laptop or computer. If you have rules for dealing with, labor employment guidelines, etc., just apply them to the mobile device. Give thought to how employees might interact. Give thought to how employees might act on behalf of your organization. There can be agency liability, sometimes established through a mobile device, but you don't need to treat it any differently than any other context where you have an employee outside your office working on behalf of the organization. If you have guidelines for configuring computers or even already phones, take those and apply them here. If you have already implemented a policy for dealing with security breaches, by all means, just sort of wrap the mobile devices into that policy. You don't need to have a standalone policy just for mobile devices. If you have processes for litigation or document retention or record keeping, then access to records through the mobile device can simply be a part of those existing policies. Safety and training, the same thing. So the good news is even though some of you may be looking at this as a new issue, it's not really new. Moreover, you already have existing policies that simply need to be updated to account for mobile devices and not the other way around.
Thank you, AJ. And now I'm going to talk a little bit about some of the real-world implications of taking the theoretical BYOD, the concept, into the workplace. In terms of an overview, you're going to start with some management issues, which are really some overarching philosophical observations about what it means to have BYOD as an employer. We'll talk some about EEO and BYOD. Certain times I think that the explosion in technology, and particularly on the apps and the like, are specifically geared towards providing new, efficient, and more graphic ways for our employees to do things we really wish that they had not. Look a little bit about the wage and hour implications and also safety concerns. And there in particular it becomes very clear that the disconnect between the speed that technology moves at and how quickly the law moves. Particularly in wage and hour, most of the rules and regulations that control what is working time and compensable time and overtime were originally drafted in the 1920s. There were updates that occurred in the 1990s, but even those are now largely outdated by today's workforce, particularly in a nonprofit sector where you're dealing largely with white-collar only workplaces that simply really didn't exist back in the day when all of these rules were created. And certainly the concept of employees having in their hand the computing power that dwarfs what was used to send a man to the moon, which is simply no one had that in mind when the rules and regulations were being put in place, but those are the rules and regulations that govern, and it creates a great deal of friction and a lot of compliance issues. Unionized workforce is a bit of a misnomer because it's likely no one here has a unionized workforce, or if so, just a handful of you. But there are labor-related issues that are implicated by BYOD, and including labor issues that affect non-union workforces. So simply because you see a union and you're not a union workforce, don't think that there are not labor implications, and we'll discuss briefly what those are. And also some international considerations. It's becoming a much smaller world. More and more associations and nonprofits have international operations and members who are overseas, and it's an increasingly difficult patchwork of compliance issues that come into play when your employees and their devices, whether they be yours or theirs, are crossing international borders. So in terms of the management issues, there was one of the founders of Intel came up with a theory that's referred to as Moore's Law. And effectively, when it was first created, it was the idea that the number of circuits that could be on a transistor would double effectively every 2 years, or rather, strike that, every year the capacity would double, which means that for the same dollar you'd have twice the computing power in the following year. And that's held remarkably consistent since really the early 40s or 50s. What that means for the devices is that they are incredibly powerful and sophisticated. And they, again, looking at the applications, the technologies, the ability to shoot real-time video, the ability to broadcast that video almost simultaneously, is just, again, something that the law is not, in employment law in particular, is just not really prepared to handle. So we'll see ourselves shoehorning those issues into the existing legal framework. And particularly on the app side, the example there is app for diabetes management. Sounds completely innocuous, but in my world, we're constantly telling employers, don't ask questions that you don't want to hear the answer to. So, if there's no workforce implication, I really don't care whether my employee has diabetes or not. And I was sort of curious when I was preparing for this, what are the other types of apps that are out there that someone might have on their phone if it's a dual-use device that your IT or the manager may have access to? What are some other things? Curiosity, I Googled Alcoholics Anonymous, 20 different apps to choose from. Bipolar disorder, there are several apps in terms of documenting one's mood to create diaries, living diaries of their moods throughout the day. If that information is on the individual's device, you are now on notice of that fact. And what are the implications of that? Implications may be none. Under the circumstances, they may be significant. But again, it's information that we'll be getting that otherwise we would not. What it really means is BYOD is combining the workplace, the public and the private. And particularly, I think we're seeing as the workforce has been getting older, we have a slew of young, newer entrants into the workforce that are used to these technologies, that their concept of privacy, the concept of I have my public self, that's where I'm at work, but then what I do in my private life is completely separate. That distinction is deteriorating to the point of virtually no longer existing. And that has some fairly significant implications. Number one, expanding the scope of employment. We are no longer an economy that people come to a large factory, work for 8 hours, the whistle rings, and they go home, and they're off the clock. So we'll talk about that notion of what is working time is becoming extremely gray. And BYOD, where it's not just my company providing the equipment, but it's my phone that I have sitting on my bedstand, and I have it on my hip or in my pocket for 24 hours a day. It's very easy for personal time to become working time that's compensable, and you'll be surprised when there's an issue how often people will claim that they were in fact working. They were answering emails, working on their tablet for tomorrow's presentation. And even if they don't claim that time now, when they're disgruntled, they most certainly will later. So EEO and BYOD, again, it's that blurring of the public and private. And I think we first saw this when email became very prevalent. And it was primarily a communication style issue, that people would say things on email that they would never think to say out loud, because it has that, it appears to be private. You're in your office, you're on your computer, no one can see you typing it. But of course, we all know it's not private. It's on the server, it's incredibly permanent, it's always going to get requested in discovery. That issue has gotten worse as the technology advances. If people had an informal communication style when we're talking about email, texting came around. And in 140 characters, people got very informal and very clipped. Texting became sexting. Now we've got video capability. And it's that notion of it's private because I'm at home, it's on my device. If you've got a dual-use device, those devices are going to be fair game when discovery comes around. And we're seeing that more and more, that plaintiffs' lawyers are requesting it, and you're seeing it more and more that unfortunate things are happening on those devices. And candidly, whether it's BYOD or not, it's happening on those devices, but it's the individual and personal devices where we see most of the challenges. Developing new policies to deal with the quasi-work environment. Most of the issues that we see now in terms of harassment and the evidence of harassment or discrimination aren't statements that are occurring in the workplace. They're occurring in that virtual world, be it Facebook, email, texting, et cetera. And with the apps, that's expanding that. I was watching the Olympic coverage earlier today, or not earlier today, it was last week, it was early in the first week. And there was a snowboarder, American snowboarder, who's being interviewed, and they were talking about the social scene at the Olympic Village. And she commented, she's like, oh, it's crazy, I had to turn off my Tinder application because I couldn't focus on my training. And I'd never heard of what Tinder was, so I went online, and it's to put a smiley face on it, it's a social networking site. It's referred to as a cruising site because you can have a Tinder profile with your picture, and you can just state that you're looking for someone to socialize with, to put it gently. Now, it's all well and good. I mean, it's consenting adults, probably not meeting anyone's definition of pornography, but it can give you the location of another profile down to about 100 feet. So imagine it's your national conference. It's the reception. You're at a hotel, you're off-site. It's a work event. One of your employees on their dual-use device has a Tinder app. They open it up, and who pops up but another coworker? Imagine if the coworker is a manager. Where do we go from there? No one knows yet. But with my management lawyer hat on, I can tell you I'm very concerned about that circumstance. And the technology is just simply making it easier for those types of issues and those types of circumstances to arise. Accommodating individuals with a disability. If it's a BYOD, if the device is a tool for use, we likely have, as employers, have obligations to provide reasonable accommodations to permit them to use the device. So it could be things as simple as larger screens, helping them with settings so it's larger type, voice recognition software, readers for email. The permutations are really endless, but it is just another issue that can go unlooked. The phone, the tablet is now a tool, and if it's related to the performance of the work, we do have obligations as it relates to individuals with disabilities. Wage and hour is a huge issue when it comes to BYOD, and here, of course, we're talking largely about the non-exempt population. Exempt employees work as long and hard as we need to, no overtime. Non-exempt, that's not the case. Primarily where we see this is in missed break time or missed lunches, and then also night and weekend work. And part and parcel of the BYOD, and again here we get back to what AJ was talking about integrating it into your other policies, is that people need to understand if it's after hours, if they're on their device and they're engaging in work activities like catching up with their email, if that's more than a de minimis amount of time, that's going to be working time. And that they need to be trained to account for that time, and we need to be trained to pay them for that time. And the Fair Labor Standards Act has a statute of limitation presumptive of 2 years. It can go back as far as 3 years. And you'll be astonished how much people will claim that they were working. And if you're not monitoring that, and if people aren't trained, and if our policies aren't pushing that towards our employees to say, if you are working off the, not off the clock, off site at night on the weekends, you need to document that time because it's compensable time, so it's paid. Employer reimbursement here, primarily California right now, there's a state statute that requires an employer to provide the tools for the position, which has been interpreted for if it's a BYOD, that there are obligations to reimburse the employee, not for the phone, but for data charges and the like that are used while they're performing services. Tracking usage of dual-use devices to track work time. Entirely permissible, but it has to be done with disclosure to the employee. There are state-level computer trespass statutes that could be implicated if someone has a dual-use device and as an employer you put software to permit us to track when they're using it and what they're using it for. In the absence of a disclosure and consent, that could trigger the computer trespass laws. Now, it's not all bad news in that regard. These tools can give employers some tools to help track hours and monitor it. Just this past week, it was helping a client who had a workforce that's entirely dispersed, largely non-exempt, and they were extremely concerned about tracking working hours and monitoring overtime. And they have an app that essentially has a countdown on both a daily and a work week countdown, that when the employee is on the clock, when they're driving to their first work site, they click a button and it starts a timer. And it runs down, and when it hits 8 hours for the day, they're to stop working. And they can tell, because they need to use their devices to perform their services, if someone is working off the clock. Now, they'll get paid for that off-the-clock time, but they will also get disciplined. So there are ways that the tools, as difficult as they can be, as difficult as BYOD can be, always be looking for ways that, that there are applications that can assist us in terms of the monitoring and in terms of our compliance activities. Workplace safety and health, OSHA. Number one cause of workplace fatalities in the United States, auto accidents. And there is a distracted driving initiative, actually, between the Department of Transportation and OSHA. It's currently limited to texting. But they have found, just given the number of incidents and the public perception of texting being an issue, and I think probably all of us have probably had the experience of being at a stoplight and someone goes blazing through it, and you can see that they're not looking forward, they're looking down at their phone. The states have been on this, and now at the federal level, an initiative to make that illegal and an OSHA violation. And really, it's got to the point of to protect yourself as an employer if you have employees that drive, and many of us do, if not all of us here in the room. It's important to have a policy that says do not text and drive. So it's clear that we're not asking them to. It's not part and parcel of their job. In fact, if they're doing that and an accident occurs, will be able to say not only was it against the law if it was in Maryland or D.C., but it violated our policy to take it out of that OSHA context. Repetitive stress injuries, see the old notion of BlackBerry thumb. It could potentially be a compensable injury. We haven't seen it yet, but I will expect to see it because I read an article recently that there's a concern that children's use of tablets and handhelds is causing nearsightedness. I hate to break it to my children. If that's the case, they're going to have the visual acuity of Mr. Magoo in about 5 years. But it's true. If someone could state that I had to use my handheld or I use my handheld as part of my job, I spend all day on it, small type, have to email, and it's affected my eyesight, you're within shouting distance of a workplace injury. So again, simply because it's BYOD doesn't mean that it's not implicating all of these various laws, including OSHA and workplace safety. Unionized workforce, clearly a BYOD policy. It affects a term and condition of employment, so it's likely something that would need to be bargained or could be subject to bargain. But more importantly for the folks in this room, your workforces are covered by the National Labor Relations Act, even if you do not have a union. Your employees are entitled to engage in what's referred to as concerted activity, i.e. the types of discussions and activities that predate the formation of a union. Employees getting together to ask for changes, or an employee who is asking for something on behalf of other workers. There's been a recent number of rulings from the National Labor Relations Board that's largely focused more on social media policies than on BYOD, but it has implications. And it's become very clear to the National Labor Relations Board that concerted activity is more likely to take place in a virtual space than in the workforce. And I think that's particularly true in a white-collar world. So many employers have policies that say that you can't disparage us, or you can't talk about personnel matters. And maybe it's tied to your communications policy or your internet or email. The NLRB has taken the position that has too much of a chilling effect. So there has to be carve-outs that individuals, if they want to complain about their supervisors, are capable of doing so. And in fact, they are able to talk about personnel matters. And that is a major change in law. It's being still hotly debated before the NLRB, but currently there are decisions both at the general counsel level and from the board itself that says certain types of policies that are fairly common are actually unfair labor practices that could be sanctioned by the board if challenged. Some international considerations. A big one is border searches. As Glenn Greenwald found out recently, the UK Guardian reporter, when his partner was stopped at Heathrow, detained, had his device taken off of him for a number of hours. Those types of searches and seizures can occur without consent and without reason to believe that a crime has been created. So if your employees are traveling overseas and they have on their device sensitive information, that information could get out in the open or at a minimum become accessed by foreign governments simply by virtue of that individual going through customs. Foreign wage and hour laws tend to be far stricter than they are in the United States. I know, AJ, when we talked the last time, there was an example that you had of an employer with the email system that queued.
Yeah, in Germany, where they have very strict laws on overtime, particularly because they have a very unionized workforce, one of the ways they control this sort of off-hour access is they shut down their network system so that no incoming email can reach the employee. After the work hour, it gets queued until released the next morning so they can maintain that sort of 9 to 5 basis.
Yeah, which was interesting because, and the reason that started that discussion was we got a question from the crowd at a prior time and said, what can you do about the wage and hour issue? And it's a very, very difficult issue to address, other than training and monitoring. That example strikes me with my management hat on as an extreme one because there are occasions where you do want someone to pick up the phone, you do want them to answer the email, but it's a good indication of how the legal structures can vary wildly. And in, we see in a place like Germany, their answer there was to simply shut it down and queue it all up, and you'd come in the next morning and have a fire hose of emails sprayed at you. But it was interesting. Similarly, international privacy laws are all over the map, and I think particularly given the scrutiny and the press that we've seen coming out of the NSA, eavesdropping, and the like, I think the international laws are going to be getting increasingly restrictive, and particularly where we have employees working overseas, where that's going to be implicated, that's going to be a growth area and just an issue that will need to be monitored and addressed. So a few lessons from the front line. The first one here, taking the bullet points somewhat out of order, is this is an incredibly new concept. The word itself, I think, first was appearing in about 2005. It wasn't really part of the usual lexicon until about 2011, which in terms of the speed of development of legal frameworks is about 5 minutes ago. So understand that anything we do in this space is occurring in a changing and uncertain legal landscape. The issue of BYOD is really affecting the traditional notion of how an IT organization is structured, or enterprise IT is structured. Previously, it was all very centralized. And you came to work, you were on your computer, you would get on our network, surrounding the network was a firewall. BYOD tends to flip that around. Now you have devices that can access it from virtually anywhere. You have devices that can pull information out of the network. That's a major sea change for how enterprise IT works. I think the cloud is making that even more difficult. So we're seeing both the technology in rapid evolution, and of course the law will be trailing miles behind the technology. When you're drafting, because of that, when you're drafting a BYOD policy, it's important to note that you've got a lot of stakeholders in the room. You have IT that's going to be responsible for making sure that the thing works, it's operational, that it's secure. You've got your management, you have line employees who will be accessing it, and questions about who has access to what types of information. For the folks in this room, you have members who are interested. Many organizations, nonprofits and associations have extremely sensitive member information, be it financial, be it their interest in certain policies or lobbying positions that are being taken. They will likely have an interest in how you are managing BYOD and how their data is being protected. So it's important to sort of identify who all those stakeholders are and make certain that all of those varying and sometimes competing interests are addressed. Employee perceptions tend to be overwhelmingly positive. There's been some surveys that suggest that the majority of employees, when they're looking at potential employers, see a BYOD policy as a good thing, as a benefit. And then, of course, at the end, how is it that you go about achieving employee compliance? No one right answer. Tends to be having the policy, but making it a living policy, making certain that people are trained on it, making certain that they understand what the implications are of failing to abide by it. Assessing your own culture of BYOD, and here we're really primarily talking, I think, about the culture of risk tolerance. And as AJ noted at the outset, I think the primary issues that we're talking about there is the competing interests of access and security. And IBM published a white paper a while back that had sort of 4 primary categories of access and security, and one was a BYOD policy that essentially has unlimited access. So wherever you are, you're on your device, you can access virtually anything on your employer's network, pull that down to you, save it on your device. That's sort of at one end of the scale. You have another version which would be only access to non-sensitive information. So maybe your personal email, maybe not even that, maybe just public information at from your employer's network, but no access to member data, et cetera. A third would be fuller access, but IT has control of everything. So yes, you can use your own device, but what you're signing at the outset says you can use your own device, but we essentially have full access to it. So we can brick it if we want to. We can wipe it if we need to. And yes, it's yours, but all the applications, all the data on that belongs to us. We have the say over what's going to go onto your computer. And then another option would be fuller access, but no local storage. And there, I mean, it's akin to the VPN structure, but without the ability to download data and store it on the local device. There's no one right answer as to which of those structures might be best for you and for your members, but those are just some sort of guide markers of potential structures. Some other basic principles that need to be addressed in the policy. Employees have to understand that simply because they own the device doesn't mean that there's an expectation of privacy. And with my management lawyer hat on, I will tell you that's one of the most important fundamental aspects of the BYOD is for employees to understand that they don't have that expectation of privacy. It's fine if they want to use their device, but the flip side of that coin is that we have to have access to the device if we need it. And the level of access can vary significantly, but I would be very uncomfortable with a BYOD policy that did not expressly address our ability as an employer to get access to the device, to access data, to download data, delete data, et cetera. The building of success, don't treat BYOD as a one-off. It has to be weaved into other policies and practices. And oftentimes, most of the issues, other than that ownership one and the privacy, is covered by other policies that are already existing in terms of your systems, in terms of communication policies. So before you start drafting the BYOD policy, get your hands around what already exists and how they can be weaved together. And then finally, training. Make certain that once you've articulated the policy, once we've struck that balance between access and security, that our employees understand it, that they understand what they can and can't do on their phones, that they understand that Tinder apps and things like that are not permitted, or the use of them. And that's going to be, and the policy, this is a slide there. Oh. Well, I just want to make sure I'm the right one. Okay. Yeah, sorry. Ongoing effort. Going to be continuous, rapid change in the technology. Remember Moore's Law, that our devices, as powerful as they are now, are going to be dwarfed in terms of their capacity within 2 years and certainly within 4 years. There's going to be an ever-increasing explosion in third-party applications. Lord knows which direction that they will be going. There's a huge market for them. That market is going to continue to expand. It's just a reality that our employers are going to have to deal with. We've seen these types of policies are often demanded by employees. The labor market will require that we go in the direction of BYOD. Again, I think that's largely generational, but I think that's going to continue to expand. A good example of that is the EEOC, which was a relatively early adopter of BYOD at the federal government. It was in 2012 that they adopted a BYOD policy. And overwhelmingly, their employees chose to stick with the EEOC-provided BlackBerry. And it was actually an EEOC administrator who made the observation. So, well, we tend to have a mature workforce. They liked the BlackBerries that they were given with. It's the only device that they ever used, so we didn't see a lot of turnover. Again, I think that universe is gone, and that BYOD is simply a reality that's here to stay. It'll be important to have whatever the process, that it be an iterative one. It's going to be a living document, going to be a living policy. I would encourage you, when you're thinking through these issues, think in terms of concepts and not the technology. Think in terms of access. What types of data to access? What types of security protocols are we going to have in place? And not focus simply on the types of technology that are here, because again, in 2 years, the technology is likely to be completely different, and your plan will be obsolete if that's where you're hanging on. A few closing observations. Implementation is key. Being active. It's interesting. When BYOD first came, it was this notion. It was attractive because your IT department could suddenly strike a line on its budget. It didn't have to purchase all of the tools anymore. And I think what was lost is, what are the resources that are going to increase as an implication of that? The biggest one is really the management now. Instead of a single platform that you have to support, you may have to support more than a half dozen different devices, if not more. And integrating all of those systems, help desk functions, they say, expect an increase in the number of calls to your help desk as people try and get their devices to speak with your enterprise work. Look at using technology to control the technology. Expansion in apps in terms of wiping technology, in terms of monitoring applications or monitoring software. Data loss prevention is always going to be a primary concern. Losing data, whether it be through the back of the taxi cab or from someone hacking a personal device, is a significant issue because we've turned the IT structure around. It's no longer a firewall and castle structure, and it's the end nodes, the end users, that may have all of the data or very sensitive data in their device. Data loss prevention is a significant issue. And finally, productivity. The IBM white paper noted that 84% of employees believe or think that BYOD increases their productivity. But to date, there really has not been a definitive study that shows that to be the case. And ultimately, that's the end goal for us as employers is, yes, it's nice that our employees like this, but is it furthering our mission? Is it furthering our business? And is it really increasing productivity? Simply because I can access Facebook and Pinterest and other things quicker on my phone during the workday, that's not advancing our interests. And if you go, and if and when I think you go the route of BYOD, it's important to constantly test, is this really working for us? And is it increasing productivity? Or is the old model better? And the answer to that really has not been answered, although I think the labor market, if nothing else, is driving us in the direction of BYOD, as is the technology.
Thanks, David. So we're going to put it all together, some closing thoughts, and then we're going to move into some hypotheticals with an approach that I don't think we may or may not have ever done with the in-person audience before, but hopefully you think it's helpful. So you're putting together your BYOD policy. I'd indicated that you don't need to reinvent the wheel, but what's critical here is you're accounting for those dual use, those personal devices that are being used for workplace reasons. What's the goal of your policy? I mean, I think among the things that we're emphasizing here, you need to set expectations for your employees. If you want right to access your data, if you want right to access or retrieve the data, seize the data, let the employees know that in advance. Develop awareness that you will be monitoring and enforcing this policy in advance so that they know that you're going to come to your phone and pull email records, for example, of all things related to your organization. If you are operating within a regulated environment that is one that includes laws related to certain information, certain records, those laws still apply to you. So you must be taking those laws into consideration when you are devising your BYOD policy, in particular health information, tax records, financial information. If you are giving thought to the practical benefits of BYOD policy, recognize that it can be useful to help minimize costs down the road. Something as simple as a support line sometimes can really be beneficial when a security incident occurs. And so think of the policy as a way to be proactive with respect to some of the things you are encountering or would have to deal with respect to employees who use dual devices for work reasons. This is litigation, records retrieval, equal opportunity considerations, talking about how employees may interact with each other through these devices, protecting trade secrets. Once you have your objectives in mind, your goals in mind, you need to figure out how you're going to translate this in a way that can make sense to your employees. And you also need to give thought to your own organization. Every organization is different. They have different risk tolerance. They have different cultures. And so you need to be addressing your organization's specific risks, not necessarily general risks that others could articulate for you. We would always recommend that you use this policy in a way where you're getting informed advance consent before you take action on the policy. And so make this a part of your policy, your handbook, your employee guidelines. Make them sign an acknowledgement form that they've received it, had an opportunity to review it. These discussion points still relate to your business, to your organization's operations. And so you do have right to control some of these elements, but it's important that you tell them in advance that even though they're using a personal device, that to the extent it relates to your organization, you are going to treat it just as if it happened within the workplace. And be adaptable to new changes. We're scratching the surface on some of these issues. As he mentioned, some of the apps that allow for particular communication, that will only become more involved. And so it would be helpful if you ask your teenagers what's current and hot in the app world so that they can be alerting you in the business world to what you need to be concerned about. Keep an eye on the future. Stay current on laws. Most laws to date do not specifically address this, but that will change. The government is a big proponent of using these devices and also a big proponent of having people have flexible schedules and working at home. So they may be driving this a little bit, even though those policy recommendations, those guidelines are written for the government. Don't ignore them. They are going to be good blueprints for your world. Follow the specific laws that do come out. Eventually there will be some very tailored to mobile devices. I think you will see them in areas where they relate to personal information, to trade secrets, and keep your policy active. It is not something that gets drafted once and gets put into a handbook and left there. It's something that ought to be revised at least on an annualized basis.
I think on that issue, it's interesting because what we're seeing are really two sets of issues that are in direct tension with one another. And I think a lot of this is coming again out of all the press around the NSA revelations, that there's this increasing interest both in data security and also in protecting personal privacy. And those two interests are in direct tension with the emergence of the technology that's making it far easier for people to get into remote devices, to see what's going on unsecured networks and the like. So when you have tension like that, that's fertile ground for regulatory action, for statutory action, and I would say, at risk of being called a cynic, where you have such fertile ground for legislative or regulatory action, the chances of all of that being well thought out and having nothing but beneficial outcomes for your organizations is very, very slim. So I think AJ is absolutely right that we're seeing some of the frameworks that are mentioned here in the policies. That's just the tip of the iceberg. And I do expect we're going to see a lot of regulatory action around these types of issues, both at the device and the data level.
So we have 4 hypotheticals, both for everyone on the phone and everyone that's in person. Unlike some of the other presentations we've given, we're going to do this one a little bit differently. Do we have a microphone so that the folks on the phone can hear? Okay. What we're going to do with each hypothetical is we're going to read it so the folks on the phone can hear, and then what I'm going to ask is for one of you to volunteer to tell us in the audience how you would devise your BYOD policy to address the situation in the hypothetical. If you don't want to answer, that's fine. You can just say lifeline and we will take over. But what we wanted to show you were some real-world examples that all of you might face, and to see how you might do it within your own culture, within your organization. So we'll start with hypothetical number 1. You're a nonprofit. You don't have a BYOD policy. You've not yet come to this presentation. During a board meeting, your CEO, and isn't it always the CEO, he references a sensitive, non-public document. In fact, he pulls out his smartphone and makes available a copy of this document without any further restrictions on its use or display, etc. So if you were devising a BYOD policy, how would you account for this situation? And let's see if we have a volunteer to handle this. Someone? Anyone?
Wait, no, I think I saw a hand over there.
Okay, right here.
It wasn't very high, but it was. Thank you for being our first volunteer.
So what we're looking for here are just some thoughts within your organization, how you might have a policy to address this in advance. You don't have to explain what you might do in response to the situation.
Well, I think it would be covered by a confidentiality and an email policy, before you even get to a BYOD policy, because it's using the corporate email to send it to a personal account, so breaking those rules already.
And she's exactly right. I had mentioned earlier in the discussion that you don't need to have a standalone mobile device policy, standalone BYOD policy. Take everything and put it into a single policy. In this situation here, what's critical is that these BYOD policies apply to everybody, including the CEO. This is not just for the rank and file. What's also critical, and she picked up on, is that it addresses email usage, and in particular, an email that likely related to your workplace, your organization. And so the policy for BYOD should be specific to your email and making clear that to the extent it relates to your workplace email, your organization's interests, that will be the subject of the policy. And finally, most important, you should have a confidentiality policy. Non-disclosure agreements should remind people that they cannot use these devices to disclose information that otherwise would be subject to that policy. It will be subject to the policy the same way any other document or computing device would be.
This is Jeff. We had a question from the from the webinar earlier that said, and it's a good illustration about how these rules not only apply to nonprofits in the employment context with respect to their employees, but to their volunteers as well. And the questioner said that they've had an issue with volunteer board members, could happen with committee members as well, using their personal devices to record board meetings, audio and or video recordings. And she asked, this is something that we would prefer not to happen. Is there anything that we can do about it? Of course, there is something you can and should do about it. In fact, we get this issue all the time with from nonprofits asking us, is it acceptable for us to record our board meetings just for purposes of the secretary or whoever is otherwise going to be taking the minutes to be able to go back and make sure they get an accurate reflection when taking the minutes, and then we might hold on to those tapes for posterity to be able to go back and check things later. For a variety of very important legal reasons, we have always advised against such a practice, and if a nonprofit does intend on its own to officially record its meetings for purposes of minute taking, that those recordings be destroyed as soon as the minutes are completed. But in this situation, with this example, there's no question whatsoever that the nonprofit should have a policy, especially if it has an issue in this area, prohibiting board members and other volunteers from recording any meetings. You can deal with issues where you can jeopardize the attorney-client privilege, you can jeopardize important confidential discussions that are taking place there, information that could later be inadvertently disclosed, sensitive employment matters, antitrust issues, a whole host of issues that can be implicated. Tax exemption related issues. We've had many situations in IRS audits, in antitrust investigations from federal and state enforcement agencies where the investigators, the auditors, the agents are looking for copies of the minutes to see what transpired at meetings. And if those investigators, even private plaintiffs in litigation, get wind of the fact that there may be a recording out there on the personal device of one of the volunteer board members, there's no question that that's going to be a target of that discovery. So bad practice, and good idea to have a policy against such a practice.
One thing to note with the policy, too, it's perfectly appropriate to tell people that they cannot use a dual device for certain things. And so don't assume that you must allow people to do whatever they want with their personally owned devices. It is okay to indicate that certain information, certain records, certain activities may not be conducted through the dual use devices. So we're going to move on to hypothetical number 2. You can see that wasn't too bad. So we're looking for 3 more volunteers as we work our way through this. In this case, your employee loses their dual-use device. How does your organization respond? Does your BYOD policy address this situation? So we're looking for a volunteer to offer tips on how our policy could be drafted to account for this situation where a dual-use device containing sensitive information, containing organization records might be lost.
I would want them to report the loss immediately so our IT staff can wipe it clean. I've been involved in situations before where that didn't happen for days. And especially if you have people traveling overseas in countries known for accessing that kind of data, it's absolutely important. We also don't let employees take devices to China and Russia that have those kinds of information in other countries as well.
That is great input, and what's critical to that is that you have a means to report the incident so that immediate action can be taken. Many of these devices now have activation features where they can be turned off, they can even be wiped. And what's critical is to give your IT department an opportunity to try and resolve the situation as quickly as possible. Also great in that response is accounting for where the device may have been lost. So if it happens overseas, it happens outside the office, you're taking that into consideration when you're dealing with that situation. But the point is, don't encourage employees to say nothing. Encourage them to immediately respond. People lose things. If you catch it soon enough, it's pretty easy to deactivate a phone and maybe nothing ever happens. And so have a simple line for them to call. Make clear that it's perfectly appropriate to respond and to deal with a misplaced item. And just tell IT so they can shut down the access. Problem solved.
And it's important that the policy is expressed in terms of the wiping. because there have been cases that have at least survived motion to dismiss. There's one in particular in the Eastern District of Pennsylvania where an employee was making a claim because they weren't on notice that the employer could wipe their device. It had a lot of personal information, personal contact, and the like. And it was in the notion of this invasion of privacy, like, computer trespass. Absolutely firm ground if you have a written policy, particularly if that the employee has signed off on that policy, that they have received a copy and understand it, that in the event the employer chooses, be it that they know the device is in an area where it shouldn't be, or if the device has been lost, that we're within our rights to simply wipe the entire device.
And as you probably heard throughout the presentation from Dave and AJ at certain points, that's a key theme, is that putting employees on notice that the employer has the right to search their devices, both work and personal devices, for various work-related purposes is critically important to protecting your organization later in the event of invasion of privacy claims and other things like that. It can, of course, be a slippery slope. It's one thing to be searching an employee's personal device to search their emails and text messages to see if there are inappropriate, say, harassing messages sent to a fellow employee or a volunteer in connection with a conference or something like that. Dave and I had a situation involving a client of ours a few years ago where the CEO ended up being terminated or asked to resign because of a situation where he was spending far too much time during the workday kind of looking at inappropriate sites on his computer. Now, that happened to be an office computer. There was no question that the employer had the right to search the web browsing history and see what sites and how much time the CEO was spending on those sites. But what if it was a personal device, and that same CEO or other employee is seemingly being very unproductive and spending half their day looking at non-work related things on their site, and the employer wants to discipline the employee, or there's an allegation of some other misconduct? Does the employer have the right to search the employee's personal device just to see what they were spending their time doing? And if it turns out that they find that they were spending half their day on personal issues that are not work related, does the employer have the right to take some adverse action against those employees? These can be difficult issues, but the key up front is to make sure you put your employees on notice about the right to monitor and search.
Yeah, absolutely. It's setting that expectation of privacy, or rather the absence of that expectation, that's important from a policy standpoint, because again, people on those devices oftentimes have personal files or folders that they view as their data. And could take umbrage if you're searching it. The privacy laws vary throughout the 50 states, but if you have a policy that's been promulgated, that's been signed off on, that says, yes, I understand that I have no interest, no privacy expectation in any of the data that's on this device because I'm going to use it for work-related purposes, you're on very, very firm and defensible grounds in those types of circumstances.
46 states to have breach notification laws for personal information. Now, when they get triggered will vary in terms of when you must provide notice to the impacted individual. Isn't really set in stone either. You would assume that it would be 24, 48 hours, something immediate, but there was a recent situation involving medical records where notification of the lost data was not provided to the individuals that were the subject of that data until 2 months after it happened. And they received a very heavy penalty for this. And so as time goes on, I think you will see more guidance suggesting when you must deal with this incident, when you must provide follow-up notice. And so having that support line, again, dealing with it immediately is critical. So let's move on to hypothetical number.
I think there's a question in the back.
Oh.
One quick question. So,
wait, can you just wait for the microphone? Sorry.
A lot of employees will, sync their devices with their home computer, things like that. So all the data that's on there presumably gets copied to their home computer. So even if I do a remote wipe of their mobile device, how do we account for all that other data that they may have on their home computer that came from their mobile device?
Interesting question. So what has been asked is, how do we account for syncing that may allow for a backup or archival copy to be made to a personal home computer at home, or even cloud network storage? That's another one. Lots and lots of employees love cloud storage. Dropbox, doesn't matter. How can we record or account for all these various copies? I mean, the short answer is right now you can't. What I can say is, in a litigation setting, the requests will be for all records, and you may need to try and account for them. The best advice in your BYOD is to try and account for managing where these records can go before the backup copy is made. I made the simple point of saying you don't need to have your dual device uses used for everything, but some of that's inevitable. Have there be some separation. A simple way that we sometimes deal with it in terms of our own communications is we have a secured network for our own work email, and then other people might have a personal email account for everything else. I mean, you can indicate that work-related email would be through one network, perhaps more secure, and that there'd be no local storage made, that you don't put it on Dropbox or some other kind of cloud solution, and that your own personal records are not necessarily going to be subject to that unless they relate to work-related. But it is a problem and an issue that probably is only going to get worse as all of these solutions move to cloud-based solutions.
And one thing would be to make certain that the BYOD policy or other communications policies or confidentiality policies expressly refer to other storage devices, copies, and so think of it when you're exiting an employee that you wipe their device and perhaps have an attestation that's signed that says I've not retained any copies in any form of any data that relates to my services to you as the employer. Is it perfect? No, absolutely. I mean, the problem is just from a technology standpoint, you can't know now. The technology and the monitoring just isn't that robust. But at a minimum, now you have a sheet of paper that if it's untrue is an affirmative representation that was made to you upon which they probably intended you to rely. Whether that's a fraud count or not, it's a very nice fact when you're building a narrative trying to defend yourself, saying that we're the good actor employer here and what we were dealing with was a bad acting employee.
Most confidentiality agreements will include a return obligation. So just make sure it at least can account for BYOD or these type of file storage situations that you're describing. All right, two more. Hypothetical 3, employees use devices infected with malware, so some type of program that's designed to cause harm, deletion, etc. How does your organization respond? How would your policy address that kind of malware situation? So do we have a volunteer to deal with this in their BYOD policy?
Trying to be a good student. It seems to me that this is a variation on the previous hypothetical, that there has to be policies about notification back to the employer and policies about how the employer is then, what rights the employer then has to wipe or to repair the system once it's been detected and then eliminated from the device.
And the response here is it's a bit of a variation of prior hypothetical number 2, trying to account for what to do in the event something like this occurs, have a ability to respond, have a support line for responses, and try and indicate to the employee in advance that there are certain files or folders that can be used, but not only with the dual device, but more important with the workplace environment. I mean, a couple other things to note to this, and these are a bit more related to basic security or IT. If you're going to allow access through a device that you don't own and control, then make sure that it has security measures on it, not only to stop people from having access without using a password, but use virus scanning software. Think of each phone as a bit of a gateway these days to pretty much everything on your network. Before, it used to be perhaps more limited records, but you need to be accounting for these devices more or less the same as laptop computers or other type of computing environments where you have unfettered access to the whole network. Have security measures in place to guard against viruses, malware, etc. And frankly, to the extent you don't have those things, then you need to be considering what people can send into the network. That doesn't mean you allow everybody to be able to send every kind of file, but these days, given the capabilities of the phone, you have to almost treat them as if they're capable of sending anything, in which case, if anything can be downloaded in, maybe you need to have virus scanning on that as well.
I think there's a question in the back.
Thank you. One of the differences between the cell phones and mobile phones and laptops is that the malware doesn't really have any of the same telltale signs of being present on a phone as it does on a laptop. So are you suggesting really that we need to be able to remotely monitor our employees' phones to ensure or identify when it is infected with malware?
The question is, do we need to be remotely monitoring? I mean, in an ideal world, you would. I'd say practically speaking, difficult to impossible. And so one of the ways you can try and account for malware is to at least make sure that access to your employer-controlled network is secured, and that to the extent you can download a file into your network and have it stored on your network server, that those downloads be subject to the same virus scanning that anything happening internally might otherwise happen. I mean, I'm sure that most of you have virus scanning software of some kind for your own internal network. And so assume that your phone can be used to similarly store records, similarly download files, and treat them the same. In terms of how you can monitor the device, which I think is somewhat what your question was at, I mean, that's one of the challenges with dual use. You may not be able to. And so if nothing else, see if you can limit the spread or scope of the malware to the device itself as opposed to your network or to other users.
Really, if you had a policy that said, if you're going to be using your own device, there's an agreement that you won't engage in certain, activities. There's a whole world of, types of websites that are known for being heavily infected with malware. And you can have an agreement. Is it a perfect, answer? Of course not, because just technologically you can't do the real-time monitoring. But if it was later found that the reason that the person's phone got infected and the reason your network got infected is because someone was visiting a website that they really shouldn't have been, whether that was in business hours or outside of business hours, if that's part and parcel of your policy, it says if you have a device you're using for work that will connect to our network, you will agree that you won't engage in certain activity, and that's an issue that could be handled by discipline. It won't help that one, but at least downstream, if employees know that they could be held accountable for infecting your network for malware because of their activities on their phone, hopefully it won't happen a second time.
The final hypothetical, you've all been very good sports about this. This one is perhaps a little bit more legal, but it's definitely something that occurs and happens and makes it a bit complicated with mobile devices. Your organization has been sued for whatever reason. You're asked to disclose records information, and those records information are on your employee's device. How do you respond to that scenario? How does your policy address that situation? We have a volunteer to take a stab at this one. If not, we can just say Lifeline, and David will answer.
We don't even have a volunteer for anyone to say Lifeline. Well, three out of 4 is not bad. We'll take that. This is a circumstance that we're seeing more and more. The plaintiff's bar is getting increasingly more sophisticated. They understand that people use their devices. They understand that people will use their private email for discussions that they might not use using their employer's domain. You do want your BYOD policy to put your employees on notice that if they're going to use their own device as a tool to perform their work, that tool is now fair game. And that we have the authority for our purposes, and defense or responding to discovery is going to be one of those legitimate purposes, to get access to their data, to get access to the phone, perhaps make an entire copy of the data on the phone for purposes of providing it in discovery. That can be a very big wake-up call for employees. And I know many of the in-house counsel that I deal with are that unique group of dual device users. Because they have a distinct understanding that their phone can be in play, that they have a phone that they use solely for work, and then they have a second device that is solely personal, and never do the two meet. And it's just to insulate themselves from having to, and it's not that they're doing anything untoward, it's just that they would rather not have to produce their personal phone and personal pictures and their kids and their personal calendar and et cetera. But in the absence of that separation, employees should be put on notice that phone and that data is going to be fair game. Now, does it mean that all of that's going to be turned over to the other side and be presented in court of law in open court? Probably not. But it can still be incredibly nerve-wracking for individuals to have their sock drawer tossed in civil litigation. But it's a definite possibility, and it needs to be articulated to our employees. Again, less of a legal issue because you're going to have to do it. We have obligations to respond in discovery, but it can be a significant employee relations issue, particularly if they're not on notice of that possibility.
And of course, all of this applies not just in the private litigation context, but we see it all the time in the investigative context. Many nonprofits get drawn into federal and state governmental investigations, enforcement actions, IRS audits, and the like, and all of these things come into play in those contexts as well.
So to conclude, we kind of summarize some of our thoughts that you've been hearing over the course of this presentation into a couple slides. They're focused on things to consider when you're drafting your policy. You can see sort of AAA, awareness, acceptance, action. One that's not on here is just simply have a policy. If you've done that, then you're already ahead of the game.
As if you don't have a policy already, you almost certainly have a practice because the likelihood of your employees not using their personal devices in some aspect of performing their services is very low. So again, it's a developing issue, but it's one where being proactive is really essential for the benefit of your organization.
You know, the policy considerations, we talked about how it needs to really integrate your culture, your organization, different department concerns, et cetera. Talking about receiving, informed consent, acknowledgement from your employee base, talking about how you need to consider what files can be stored, what communications can be established, who will use compliance with laws that might apply to your organization, record-keeping obligations might apply to your organization, training, monitoring, and staying current with your policy, at least updating on an annualized basis. Ultimately, and we get this question all the time, do you have a form for this? We really believe this one, among many others, is really critical that you devise a form that fits your organization. We can't tell you if your culture supports BYOD. It's perfectly appropriate to say that we don't support BYOD. That can be your policy. So these things really need to be tailored to your organization. And if you are going to support it, then you need to give thought to what kind of access privileges you will permit, who can use, when, and what records may be accessible. All those things are going to be unique, which is why we really advocate sort of this cross-disciplinary approach where you have all the various stakeholders looking into this and considering all the issues that go with this. And with that, I think we have a couple minutes for questions.
We do have a few minutes for questions. Before we open it up for questions, I just wanted to point you to a few resources. And you see up on the slide right now at the bottom there's a few links. I didn't mention this at the top of the program, but our nonprofit practice maintains a pretty voluminous library of information content online on various nonprofit legal topics that's very easy to find and to search. We have lists of libraries of articles and PowerPoint presentations. We, of course, have a listing of all of our upcoming events. And then we also have under venable.com/nonprofit/recordings, recordings of all of these monthly webinars that we do and some other ones as well over the last 3 years. And I just wanted to highlight a few of them that touch on topics that we talked about here today. If you want to get more information on any of these topics or you want to share these with your colleagues, at that link you'll find, and AJ and Dave were involved in a number of these. Last September, AJ was involved in a program called What Your Nonprofit Should Know About Apps, the Cloud, Information Security, and Electronic Contracting. Last June, I think you also did social media legal risks for your nonprofit. Last March, preparing an online social media policy for your nonprofit. Last January, we did a program on exempt versus non-exempt employees, a very important issue which we didn't talk about too much here today, but very significant implications involving bring your own device in terms of when non-exempt employees are working and when they're not, when you have to compensate them and when you don't, and strictly regulating employees' use of their own devices to do work. It's a critical issue to minimizing compensable time and avoiding unexpected surprises. March of last year, helping nonprofits manage employee privacy. In September of 2011, we did a program on telecommuting employees for nonprofits, an area that really touches on many of the same issues that we talked about here today. This is kind of the next stage of telecommuting, but that was a great program. And then finally in July 2011, we did a program that just focused on compensable time issues for non-exempt employees. So if you want to get more information on any of that, please take a look at those resources. Any final questions in the last few minutes here for Dave or AJ? Well, if not, I want to thank both of our speakers for a terrific job today. They managed to pack a lot of information into a short time. Hope you guys found it valuable. Thank you for participating, and we hope to see you back here next month. Thank you.